awarded the death sentence, it's generally perceived as being a correct judgment and a correct sentence, primarily because three courts, the trial court, the appellate court, and the Supreme Court, have confirmed the decision. Actually, most people don't know how the system works. Very often, persons who are convicted of these very heinous crimes are represented very, very poorly in the trial court. And because of poor representation, they're unable to prove their innocence, or at least unable to establish some of the chinks in the prosecution case. This continues in the High Court and in the Supreme Court. In a large majority of cases, the people who are convicted to death are people who come from the lower stratas of society, who are unable to employ or deploy very senior lawyers. Lawyers who are expensive, lawyers who will fight their case with the kind of dedication that is required to fight cases of this nature. As a consequence, they are left to legal aid lawyers or amicus curiae, some of whom are very good, but most of whom are disinterested in the facts of the case. There are on most occasions there are no meetings with the convict or with the accused person, and as a result of that, the story that the accused might have in his defense is not brought out in trial. The same process happens in the High Court, and in the High Court although there is a murder reference and the High Court is supposed to review the evidence in minute detail, it doesn't necessarily happen. As a consequence of this, most persons who are awarded the death penalty are those persons who have received very poor representation, who are victims of poor investigation and completely inadequate scrutiny by trial courts as well as the First Appellate Court. By the time the matter reaches the Supreme Court, two courts have already given a finding against this particular accused, and the Supreme Court is tempted to give an identical finding without really reviewing the facts of the case in minute detail. I think at the end of it, we all forget that the life of a person is being considered, and that death penalty will take away the life of that person, but we do not scrutinize the evidence with the kind of care and caution that is required. As a person who's worked both in the trial court and in the High Court, I'm sometimes amazed at the kind of evidence that passes off as evidence. This is so typical of trial courts, so typical sometimes of High Courts, that evidence which should never be admitted as evidence, which should not even be called as evidence, is considered as incriminating evidence against an accused person. Rules of the Evidence Act are done away with. Hearsay evidence is admitted. Evidence of very, very low caliber is sometimes treated as best evidence against this accused person. So if you look at conviction orders, most of the time you find a lot of chinks, not only in the prosecution story, but also in the reasoning of the court. One of the classic examples of how the system goes terribly wrong is the case of the Vinder Singh Bhullar, which came up to the Supreme Court. Two courts had awarded death sentence. In the Supreme Court, a 3-member bench examined the SLP of the convict. 2 judges convicted or upheld the conviction of Bhullar and upheld the death sentence granted to him. But one judge, Justice M.B. Shah, acquitted Bhullar. Now this is such an anomalous situation. It's so crazy that not only do you have difference of opinion with respect to quantum of punishment, you have difference of opinion with respect to the innocence or guilt of the person concerned. If a judge of the Supreme Court has acquitted the man, clearly that is a case where the death sentence cannot be awarded. And yet the death sentence was awarded. And the death sentence was awarded because the majority view was that he was guilty of the offense and therefore the death sentence was awarded. Now these kind of situations show how terribly precarious and how terribly wrong some of our systems are. it establishes beyond reasonable doubt that it is never possible to establish beyond reasonable doubt, at least in most cases, that a particular person has committed the offense or has not committed the offense. Awarding the death penalty and executing a person on the basis of this kind of evidence, therefore, is morally, legally wrong, and no civilized jurisprudence should be able to get away with it. The other issue, of course, is that the stringent tests that the Supreme Court itself has put in place to decide what constitutes rarest of rare case is never actually followed by the trial court and the High Court. The Supreme Court has said in several cases that to decide whether a person falls within the category of rarest of rare, a separate evidentiary hearing should be held so that the trial judge is satisfied that the case falls within the parameters of rarest of rare. Now that never happens, but a mechanical death sentence is awarded because of various pressures: societal pressure, political pressure, media pressure. These are not pressures that should ever enter the space of judicial findings, but it does enter judicial determination, and it does influence the minds of judges. And when that happens, awarding an irreversible sentence like the death sentence becomes that much more problematic. The last and perhaps the most important reason why we should relook this whole aspect of death sentence is whether in a country which prides itself of being a constitutional democracy, of having a constitution which has withstood the test of time, whether a country like ours should have the death sentence as part of the statute at all. I don't think there's been enough debate about the morality of the death sentence, the fact that it completely does not act as a deterrent in preventing crime. That debate is absent. We by and large follow the lynch mob mentality. We encourage the eye for an eye kind of situation where we encourage society at large to expect the death penalty to be awarded. And I think that's very problematic, because we need to look into the fact that almost all civilized countries in Europe have abolished the death penalty. They have a lower crime rate than ours. The death penalty does not in any way prevent or act as a deterrent for crime. But that kind of debate has not taken place in India. My concern as a lawyer is a concern my concern is based on several facts. One, that our systems are not strong enough to award punishments. Very often the conviction orders are based on not credible evidence, and therefore to award the death penalty purely on perception is very, very dangerous. Secondly, I think the rarest of rare formula which the Supreme Court has put in place is not followed in most cases. And lastly, I think as a society we need to debate whether at all this provision, the morality of having the death penalty as part of our statute book, whether a country like India should have it at all, and whether it serves any useful purpose other than satisfying the lynch mob.